we are now going to introduce you to the Constitution of India. To understand the welfare functions performed by the state in India, it is imperative that a well-rounded understanding of India's governmental structure, including its aspirational goals and instrumentalities for achieving the same, be developed. The state in India derives its legitimacy from the acceptance by the Indian populace of the Constitution of India. The Constitution of India is the core document which establishes, defines and circumscribes various dimensions of government functionality. At this stage, you might be moved to ask, what are the functions of a constitution? To answer that question, we need to look at what are the functions a constitution can perform. A constitution is a document which underlies the fundaments of any country's governmental setup. India is characterized by one of the most diverse populations in the world. It is characterized by variations on all possible axes, for example, language, race, religion and region. This variation is the fundamental contributor to variations in aspirations which Indians as individuals and groups have from the lives they lead. To ensure that these aims and aspirations are pursued in a manner which does not inhibit the exercise of similar rights by others, the Indian Constitution establishes a catena of institutions which ensure that cooperation and not conflict marks the mutual interaction of India's diverse population. To put it in simple terms, the primary function of a constitution is to provide a set of basic rules that ensure minimum coordination amongst members of a society. This is the most basic function of the constitution. However, Indian constitution and several other constitutions are not only constitutions which underline the fundamental rules of governance. These constitutions also lay down the aspirations of the society which they seek to lay down the rules to control. An example from the Indian Constitution would be the directive principles of state policy. The directive principles of state policy under the Indian Constitution do not lay down minimum rules. What they state is what the state aspires to do, what the people of India should do, and what the governments must strive for. For example, it seeks that the government should try and make available to people employment in such a form which leads to fullest utilization of their abilities. Under the fundamental rights, it is sought that people should be treated equally, that people should have a right to a decent life, that people would have a freedom of expression. Now, as you see, these are not mere rules which ensure that people do not fight. These are actual aspirations. These are additions to the qualities of life. Therefore, we see that the Constitution is not a mere dead document. It actually strives to add to the value of people. From there, we come to another extremely important factor in Constitution as a piece of law. Constitutions are not static. Constitutions need to change in unison with the societies in which they operate. Thus, all constitutions need to change, need to be amended from time to time. Therefore, we see that the Indian Constitution also has inbuilt system of amendment. However, there are certain restrictions on how that amendment can be made. Let me bring you two instances other than India which will tell you where does India stand on ease of amendability of the Constitution. The British Constitution constitutes all the legislation which are passed in Britain. Anything can be amended in the Constitution in the same manner as a simple legislation. It is a Constitution which is very easy to amend. On the other hand, the Constitution of United States of America is extremely hard to amend, as not only the center but states also need to concur for an amendment to be effected. India stands somewhere in between these two. For certain changes to be brought about in the constitution, for instance the change of name of the state, reformation of state boundaries or formation of new states, only an amendment, only a normal legislation needs to be passed by the central legislature. On the other hand, there are certain amendments, for instance those which affect the federal nature of Indian polity, in which case the central legislature along with the state legislatures have to pass enactments. We find that India does not have a very rigid constitution. This is in conformity with the nature of society which the Constitution of India seeks to convert India into. Now we will look at the various aspects of the formation of Indian Constitution. The Constitution of India is a supreme law of India, as we had discussed earlier. It lays down the framework defining fundamental political principles and establishes the structure, procedures, powers and duties of governmental institutions. The Constitution of India was not made in a day. It did not come into its current form in one day. It was drafted by a Constituent Assembly. However, it must be remembered that the Constitution of India did not or was not entirely the work of the Constituent Assembly alone. It had been in the formation from before. Before independence and before the promulgation of the Constitution of India, the British ruled India. They had passed a multitude of administrative measures. They had passed a multitude of legislations which applied to India. Those legislations had already set in motion a certain type of governmental structure in India. Various acts of the British government were therefore already in existence, which were guiding the governance of Indian territory. This was followed by the Act of British Parliament in 1935 called the Government of India Act 1935. The Government of India Act 1935 was a very different sort of legislation from the previous acts of the British Parliament. It actually laid down a very extensive administrative setup in India. Though the power was not entirely in the hands of Indians, it did seek to give some power to Indians. It also sought to set up a federal sort of structure. Now, this act, the Government of India Act of 1935, was the foundation on which most of the rest of the constitution was made. However, make no mistakes in believing that the Government of India Act was the core of the Constitution of India. The core of Constitution of India was almost entirely formed by the opinions of those who sat together and formed the constitution in the Constituent Assembly. The Government of India Act basically laid down the administrative structure. The parts such as fundamental rights, directive principles of state policies, preamble and other such parts are entirely new, though they may have been taken from various other constitutions, and Indian Constituent Assembly members were very aware of the fact that constitutional governments had been in existence in various other countries, and we took whatever we thought would be beneficial to India as a country from those constitutions. Now, let us look at the various parts of the Constitution of India. The Constitution of India is composed of various articles and certain schedules. These articles lay down the various laws, lay down the various provisions on which the governance is to be carried out. The schedules, on the other hand, lay down other things in detail which are not included in the articles themselves. Indian Constitution currently has more than 400 articles and it has around 12 schedules. We will now take a look at the content of some of these parts. First and foremost is the preamble to the Constitution of India. It lays down the aspiration, it declares the source of the power of the Constitution of India, which is obviously the people of India. Then part 1 deals with the union and its territory. The union and its territory defines the territorial scope of India. Part 2 deals with citizenship of India. This was important at the time of when the Constitution of India was adopted, because there were serious issues regarding citizenship, as a large number of people had migrated to Pakistan and some had come from Pakistan. Also, citizenship laws needed to be clarified. Part 3 deals with fundamental rights. This part has been called the heart and soul of the Constitution of India, as this is what converts Constitution from a merely law-laying document to a document which empowers people. Part 4 deals with the directive principles of state policy. We will deal with these parts later, but in brief, directive principles of state policy are non-enforceable directives to the government as to how to run the state and what to seek in that process. Part 4a deals with the fundamental duties of citizens. Part 5 deals with the way the union government is structured. Part 6 deals with the states and how the administration should be run there. Part 7 deals with states in the B part of the first schedule, though this part has been repealed now. Part 8 deals with the union territories. Part 9 deals with the panchayats. Part 9a deals with the municipalities. Part 10 deals with the scheduled and tribal areas. Part 11 deals with relations between the union and the states. It is a very important part, as India being a federation with more powers to the center, there needs to be a method, a mechanism of ensuring that proper coordination is achieved between these parts. Part 12 deals with finance, property, contracts and suits against the government. Part 13 deals with trade and commerce within the territory of India. Part 14 deals with services under the union and the states. Part 14a deals with tribunals. Part 15a deals with elections. Part 16 deals with special provisions relating to certain classes. Part 17 deals with languages. Part 18 deals with emergency provisions, which are certain provisions which come into force when the normal functioning of the country is interrupted. Part 19 deals with other provisions. Part 20 deals with amendment of the Constitution, and other parts, there are other parts which deal with temporary, transitional and special provisions. And lastly, the part on short title, date of commencement and authoritative text in Hindi and repeals. As you can see, the Constitution of India is an extremely detailed document. You would not find this sort of detail in most other constitutions. Therefore, the Constitution of India is the lengthiest constitution in the world. The reason behind that is, it does not only deal with the functioning of the union, it deals with the functioning of the states, it deals with many other matters which you would normally find in regular laws of the countries. Therefore, India has the longest constitution, but there was a reason behind it. At the time of independence, many things needed to be clarified well in advance, so that there are no hiccups in the running of this nascently formed country. Now let us look at the schedules to the Constitution of India. Schedules are lists in the Constitution that categorize and tabulate the bureaucratic activity and policy of the government. The first schedule deals with the lists, the states and the territories of India. Schedule second deals with the salaries of officials holding public office, judges and Comptroller and Auditor General of India. The third schedule deals with the forms of oaths. This lists the oaths of offices for elected officials and judges. Fourth schedule deals with the allocation of seats in the Rajya Sabha, which is the upper house. The fifth schedule provides for the administration and control of scheduled areas and scheduled tribes. Sixth schedule deals with provisions for the administration of tribal areas in Assam, Meghalaya, Tripura and Mizoram. Seventh schedule deals with the union, state and concurrent lists of responsibilities and powers. This schedule is extremely important, as it basically deals with what areas can any particular government legislate in. Eighth schedule deals with languages. Ninth schedule deals with those articles which are immune from judicial review. The 10th schedule deals with anti-defection provisions for members of parliament and members of the state legislatures. 11th schedule deals with Panchayat Raj, or rural local government, and 12th schedule deals with municipalities. After having detailed various parts of the Constitution of India, now let us look at the sort of system of government which this Constitution seeks to establish. India is a democracy. Above all, Indian Constitution seeks to convert the form of government in India into a form of government wherein people have the majority say, people have the say in the running of the government. Therefore, the final and ultimate authority under the Constitution of India are the people who are governed by it themselves. This is the core of the Constitution of India. India is a democratic country, and therefore the writ of the people themselves runs large. Since the ultimate will is that of the people, the government at both the centre and states, the highest functionaries of these governments, are formed by the people themselves. The people vote in regular elections and thereby select those people who they wish to lead them in the government. Therefore, the executive branch of the government is formed after elections, after the votes have been polled, and those who gain the majority of votes in these elections get to run the government as the heads of its executive wing. Other than a democracy, the preamble declares India to be a secular country. We must understand that secularism has different connotations in the West and in India. In the West, secularism means separation between the church and the state. Therefore, there is to be no interaction whatsoever between the state and the church. However, in India, this is not the case. In India, there is supposed to be an active collaboration between religion and state, but there should be no religion which gets a preferential treatment from the state. Therefore, the core of Indian secularism lies in equal treatment of religions and not disregard of religions. India is a sovereign country. By sovereign country, we mean that Indian state takes orders from no one except its own institutional mechanisms. Sovereignty essentially means to not have an external person dictating the terms of governance to Indians. India is also sought to be a republic wherein rule of law is the mode of governance, and the head of the government is elected by the people themselves. Alongside all these factors, the Constitution of India seeks to make the government of India focused on the welfare of people, and therefore it seeks to convert India into a welfare state also. The preamble also declares that India is to be a socialist state. By socialism, what is meant is a state which seeks to benefit all and does not seek to focus on the benefit of only a select few. The meaning of socialism has been under constant change with the change of time. However, it is widely accepted that socialism does entail opportunity to all, availability of minimum facility to all, amongst other things. After having looked at these important aspects of the Constitution of India, we would now be looking at the various subparts of the Constitution of India in slightly greater detail. Let us now look at the major functions performed by the Constitution. As you would have understood from the previous discussion, Constitution seeks to bring minimum uniformity amidst diversity. To achieve this, the Constitution specifies some fundamental rules. These can be understood on the following parameters. First, the designation of institutions to perform particular functions and establishment of methods which ensure that the institutions stay within their respective limits. Second, the specification of decision-making power. And third, the enumeration of aspirations and goals of society. We would now look at these parameters more closely. 1. Designation of institutions to perform particular functions. The Constitution of India, through Article 1, lays down that India shall be a union of states. The units so designated states are the primary institutions defined by geographical boundaries and separate institutional arrangement of their own. These states come together to form the Union of India. It must be noted at the outset that states are not the only constituents of India, and there are other areas called union territories and national capital territories. This division of India into smaller units gives India a federal structure, though the word federal is not used in the Indian constitution. Federalism is a political concept in which a group of members are bound together by a covenant with a governing representative head. The term federalism is also used to describe a system of the government in which sovereignty is constitutionally divided between a central governing authority and constituent political units like states or provinces. Federalism is a system based upon democratic rules and institutions in which the power to govern is shared between national and provincial state governments, creating what is often called a federation. It is often debated whether India is a true federation or not. As you would understand Indian constitution better, you will find that though India is divided into smaller units, the division of power is not equal and the balance tilts heavily in favor of the central government. Thus, India has been often described as a quasi-federal state. This uniqueness of Indian federalism stems from the peculiar conditions of Indian society and the political imperatives at the time of Indian independence. Beyond this basic division between governing units, the constitution broadly divides both the central government and the state government into three parts: the legislature, the executive and the judiciary, the detailed functions of which you would read in a later chapter. However, it is imperative to state the rationale behind this institutional structure. This division of governmental powers in three parts draws on the theory of separation of powers enunciated by Montesquieu. The powers are divided between a multiplicity of institutions, and they ensure that no single institution can run without checks and balances. Thus, the judiciary has the power of judicial review of legislative enactments as well as administrative actions. Further, the parliament is constantly scrutinizing the functioning of the executive. The parliament is also periodically responsible to the electorate through general elections. These measures ensure a well-balanced and responsible government. After this, the second area of decision-making is also dealt with in detail by the Constitution. Indian Constitution envisions India as a democracy, which essentially means that the ultimate decision makers of their fate are the Indian people themselves. The simplest method of achieving this objective is, as you know very well, the periodic general elections. When we look at these various methods of ensuring that the government is run not by any group, not by any particular sets of individuals, and not by any one person, we find that the Indian Constitution essentially seeks to make a system of governance which is free from arbitrariness, which actually seeks to follow the constitutional goals and principles as were enumerated by the Constituent Assembly and as have been added or removed by amendments after that. To summarize our discussion on the Constitution of India, we have seen that through the preamble, the Constitution declares India to be a democratic, sovereign, socialist republic. It also seeks to grant various fundamental rights to its citizens, and it also seeks to direct the government to move in a particular direction through the directive principles of state policy. We have seen the various parts of the Constitution of India, and we have also seen the various schedules which are there. We have also seen how the Constitution of India seeks to control various parts of the government and what are those various parts of the government of India. Therefore, we can say the Constitution of India essentially seeks to lay down a governmental structure which tries to bring in a uniformity or a similarity of objectives at a basic level, at a fundamental level, so that people who have different aspirations and goals strive to achieve the same without hurting the rights of others.